Okay, folks, my name is Doug Pinkham. I am with Pinkham and Associates, a dedicated family law firm in Orange County. I am providing this video to help you understand the attorney's fees and costs order attachment. This is the FL 346. Let me explain this form. This is the form that a judge is going to sign after you have requested attorney's fees and the judge has ordered the attorney's fees. This is the order for attorney's fees. Okay, so I'm going to start at the top. I'm kind of pinching this form off. Okay, so I know some of you can see this form on the video. That's fantastic. Just follow along line by line. Those of you that do not have the form on the video itself, there's a link below. Pause this video, click on the link, get the form, put it in front of you, and follow along line by line along with me. All right. I'm going to presume you already have that form in front of you. So let's start at the top. Just like all of these forms, list the petitioner's name, the case number, the respondent's name at the top. Again, the petitioner and respondent's names never change. It's the same as on the petition and summons from the very beginning of the case. Then, this form is going to be attached to a findings and order after hearing, a judgment. For paternity, it's going to be a judgment for dissolution, FL 180, or some other order. It could be an order. It could be some other order that came from a request for orders or something like that. Order after hearing, that kind of thing. So mark the box that applies or put other and then mark what it's attached to there. Then notice it says the court finds. So these are the findings that the court made. These are the rulings that the court made after you made a request. And you submitted all of your requests and all of your reasoning and all of the, what you want, how much you want, why you want it, why it's reasonable, all of that stuff. Once you've submitted all that and the judge has reviewed it all and the judge makes an order for attorney's fees, this is where this comes in. So the judge finds an award of attorney's fees and costs is appropriate because there is a demonstrated disparity between the parties in access to funds to retain and maintain counsel and in the ability to pay for legal representation. Let me explain that and let me give you a little background. In family law cases, you can ask the other, and I explained this on a attorney's fees general video previously, which you probably watched. But just generally speaking, in family law cases, the larger wage earner can be held to pay the attorney's fees, some or all of the attorney's fees, for the other party. It's usually based on one of a few different factors. One, simply one party has access to funds, the other one doesn't. Huge disparity in income, that kind of thing. Just picture one party is a doctor, works 65 hours a week, and earns, $260,000 a year. The other party stays home, has been raising children for 20 years, has no job, no income, without the savings from doctor other party. There's no money. Without the credit cards that are based on doctor other party's income, there is no credit cards. Without, so all the money comes from, doctor other party. So how would this other party who has no income, no credit, no nothing, how would they be able to go out and hire an attorney that could equally battle the kind of attorney that this doctor other party is going to hire? Okay, they can't unless they get assistance in providing or paying for those attorney's fees. That's exactly how this is, and that's exactly why this system works this way. California law says that both parties should be provided equal access to justice, and that means equal access to equal level of legal talent, legal experience, that kind of thing. So that's why the larger wage earner can be held to pay for the attorney's fees for the lower wage earner or the non-wage earner. Another way that attorney's fees can be ordered from one party to the other is if one party's doing some things wrong, doing some things in bad faith. being a bad boy, doing things wrong, or a bad girl. Those are the two major reasons why and how you get attorney's fees. Anyway, that's what one is talking about. And then you're going to mark A or B if or the judge will basically mark this box or tell you how to mark this box. A says the party requested to pay attorney's fees has or is reasonably likely to have the ability to pay for legal expenses. That one has to be marked if the judge makes a finding based on ability to pay. And B, the requested attorney's fees and costs are reasonable and necessary. They're also going to mark that one. They have to, or they're not going to order attorney's fees. 2 says an award of attorney's fees and costs is appropriate because, and then you're going to need to check the boxes, or a judge, again, would check the boxes that apply. There is not a demonstrated disparity between, oh, by the way, 2 says an award of attorney's fees and costs is not appropriate because, and then they're going to mark the appropriate box if they're not going to grant attorney's fees. And then 3, the judge could make other findings and handwrite them in. See it happen all the time. It could be an infinite number of different arguments and issues with regard to, I'm going to give this amount, but only for this, and this is why, and I've seen all kinds of things in there. So this is generally going to be filled out by a judge, or they're going to tell you what to put in here before you file it. Then comes the actual court orders. So if the court's going to order attorney's fees to be paid, 4 says the petitioner or the respondent or some other party to pay attorney's fees and costs in this legal proceeding be in the amount of 1, fees. So the judge will mark that and say $25,000 in fees, $435 in costs, or $635, whatever it might be in costs. And then 3, interest is not included in and is not waived. So a judge is likely to mark that. But it's a non-issue. It's not that big a deal for this particular video. And you can mark that just in case you think or may think that interest in the future may be requested or desired. You want to make sure that you're marking here that you are not waiving the interest that may accrue. C is payable to. So whoever is going to receive this money could be the petitioner, could be the respondent, and it could be that the judge is going to write in there or tells you to write in there petitioner's counsel, so that the $25,000 gets paid directly to petitioner's counsel. So it goes into the trust account or whatever. Or maybe $25,000 worth of fees have already been accrued and earned and just has not been paid. It's already owed. So the judge may say, even say, I'm going to order $70,000 worth of attorney's fees. $45,000 needs to go into a trust account, and $30,000 goes directly to petitioner's counsel. That kind of thing. It's whatever the judge orders. D says from the payment source of. Now this is huge. This is key. You're not likely to get an award of attorney's fees unless you can prove that there is a source of funds. And I mean a source of cash. Just because Dr. Other party makes $260,000 a year, he might also drive a Lamborghini, have a house on the beach in Newport Beach, go to, 5 Crowns and 16 other expensive restaurants every single night, and at the end of each month, they're accruing an additional $5,000 a month in credit card debt because they're living way above their means. If that's the case, there's probably not a large pool of money from which to pay a $75,000 fee award, or even a $7,000 or a $4,000 fee award. So you're going to want to, when you're asking for attorney's fees, you're going to want to say, look, there's $36,000 in this account. There's a 401k from which we can borrow money from in the amount of $136,000 or $2.4 million. I don't know. I don't care. But whatever it is, you're going to want to show something more than he's got a $30,000, Visa card, or he's got a Amex card, a black Amex card that has no limit. Those aren't good ways to ask the judge to pay for your attorney's fees. They might order it, I've gotten orders on countless occasions where the judge said, "Sorry, sir, liquidate part of your 401k and pay the attorney's fees." So they can be done that way. It's just a little harder. If there's a savings account with 50 grand in it right there, that's going to be a super easy way to source the funds to pay for attorney's fees. All right, folks. So the court orders to pay in the amount of blah, 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 payable to, and the payment source. That's where we got to. All right, so going to page 2. Again, the top of the page, put the petitioner, the respondent, and the case number off to the side. E says, with a payment schedule. All right, so on occasion, a judge might not say, go attack the 401k or go take all the $50,000 out of the trust or the savings account and pay it all over to respondent's attorney or whatever. The judge might very well say, you need to pay, for example, one says, due in full, on or before a certain date. 2 says, to be paid in installments. So they're going to make monthly payments in the amount of $1,000 a month, due on the first day of the month, beginning, say the first day of next month, whatever that date is, and it needs to be a specific date, until paid in full. So let's say the judge orders $26,000 in attorney's fees. This happens a lot at the end of a divorce case and at the end of the judgment, and at the end the judge compares everybody's attorney's fees and everybody's income and makes an order, say the respondent needs to pay the petitioner or the petitioner's counsel $26,000 in attorney's fees. And he might say $1,000 a month, due on the first day of every month, paid directly to respondent's counsel until paid in full. So that attorney theoretically is going to expect to receive $1,000 a month for the next 26 months. And they don't typically have interest connected to it. So it's usually just a flat payment. But that's what that's about. 3 says, and this is enforcement language, if any payment is not timely made, and more than, say, 3 days late or 7 days, whatever the judge orders, and the entire unpaid balance is due and owing immediately. So that's just to say, let's say they ordered that $26,000 to be paid $1,000 a month, and he pays 3 payments, but the 4th payment's late and doesn't pay it for 15 days, but he's only given a grace period of 5 days. Theoretically, that remaining, what is it, 22,000? 23,000, whatever's remaining is owed immediately, all of it. And sometimes we had to go back into court and we got to ask and explain to the court we didn't get the payment. Court ordered he had 5 days. We gave him 15. He didn't pay it. Judge will say, pay it now, sir. Take it from the 401k. Do whatever you need to do. 4, like I said, this is usually common. No interest will accrue as long as the payments are timely made. And then if the judge makes any other orders, that's what would go under 5 other. All right, so 5 explains what the fees are and what they include. So again, the judge is going to fill this out for you anyway, or tell you how to fill it out. So they will give you the information in this section also. And then, of course, any other orders down here in 6. That could be anything. Again, with regard to attorney's fees, I've seen a ton of different, funky orders, and and they, because the judges are trying to be fair and trying to be, the whole purpose of doing this is either trying to be fair and trying to make sure everybody has access to appropriate representation, or they're trying to spank the other side because they did something wrong. Either way, it's not uncommon to see something put in here, or the judge order you to put something in there. If so, you'll know about it. The judge will tell you what to put in there, or they'll write it themselves. Just a notice on the bottom, I'll read it out loud because it's important. Any party required to pay attorney's fees and costs must pay interest on overdue amounts at the legal rate, which is currently 10% per annum, per year. So when I said that there's typically no interest on that, you'll see up there on 5, was it 5? I don't remember where it was at, but somewhere right above here it said that there's no interest due so long as they're being paid on time. Yeah, it was 4E sub 4. No interest will accrue so long as the payments are timely made. So if they're not timely made, yeah, you're going to get hit with 10% interest per annum. So, and it adds up. Boy, that adds up quickly. Next year, it's 10% on top of the amount owed plus the 10% interest you had last year. So it's interest on interest. So be careful. If you're ordered to pay attorney's fees, pay them. Get it over with. All right, folks, that is the entire FL 346, the attorney's fees and costs order attachment. I hope this video was helpful, and I will see you on the next video.